of Now This and the Appeal. I'm Alana Sivan. Today we're going to be talking about pretrial detention and how the legal system determines who sits behind bars before trial and who gets to go free while they wait for their day in court. Now, this process is different across the country because there isn't a uniform system of pretrial detention. Different states do it differently. So in many states, they rely on a system of money bail. And in those systems, if bail is set on your case, whether or not you get to go home while your case is pending, while you're waiting for your day in trial, depends on how much money you have in your pocket. And like so many aspects of the criminal legal system, the burden of this process falls heaviest on people who are not white. According to the Prison Policy Initiative, people who are Black and brown receive bail amounts that are twice as high as bail amounts for white people, and they are less likely to be able to afford it. And so that's how it works in money bail systems. But there are also some places that have moved away from cash bail, from money bail. And in many of those places, officials are turning to algorithm risk assessments. And basically, these assessments quantify how risky it is to let someone go before their trial. They essentially say this person presents this much of a risk of dangerousness, and because of that, we will or will not choose to lock them up. But even though there is no money bail in this system, it produces very similar outcomes. So when ProPublica assessed the outcomes of a risk assessment on criminal cases in Broward County, Florida, in 2016, they found that even when controlling for prior crimes, age, gender, people who are Black were 45% more likely to be assigned higher risk scores than people who are white. And so you may be wondering, why is the government allowed to do this? Why is the government allowed to detain people pre-trial when, one, these decisions aren't really made based on a safety profile, but on socioeconomic class and the color of their skin. And two, the folks who are being detained haven't even been found guilty. Well, here's the surface sort of legal answer. And that's that the Constitution allows the government to detain people before trial. They can detain someone before trial so long as the government's interest in safety, quote, outweighs that person's interest in liberty. And so in other words, it's saying, okay, we need to lock this person up for the public good. We need to strip them of their liberty to prevent future crime and to make everyone safe. But as we've seen, this is really flawed because there's no good way of determining benefit to safety. And when governments try to make that calculation, it's often shaded by race and class. And one reason for that is because of the fundamental flaw behind the risk assessments themselves. And our guests today are going to talk a little bit about that. Megan Stevenson and Sandy Mayson have laid out in a recent research paper that the legal system has, in this calculation, ignored the harm that pretrial detention causes to the people detained and doesn't take that into account when considering a public safety analysis. And so as a result, some 500,000 people sit in jails nationwide awaiting trial on any given day, facing a form of punishment, even though they are legally presumed innocent in the eyes of the law, and even though these quote unquote benefits to public safety are really speculative at best and often based on racist algorithms. And in their paper, Stevenson and Mayson outline what they describe as a more balanced model for making choices about detention. And using this new cost-benefit analysis, they conclude that jail is so harmful, particularly pre-trial, that virtually no one is quote unquote dangerous enough to warrant pre-trial incarceration. And so for more on this new model and what it means for the future of criminal justice reform, I'm so pleased to be joined by the new authors of that recent paper, Megan Stevenson, a professor at the University of Virginia Law School, and Sandy Mayson, a professor at the University of Georgia School of Law. Thank you both so much for being here.
Thank you.
Thank you so much for having us, Alana.
So I want to start by talking about how in your paper, I found this to be really helpful, to see how you distill the basic cost benefit analysis that takes place when weighing risk or dangerousness as a consideration for pretrial detention. So I was hoping you could start out this conversation by giving us sort of a hypothetical example of what this looks like in practice, how these sorts of decisions are made. Megan, I can start with you.
Sure. So you mean in real life? In real life, the way a bail decision is made is like appallingly cavalier. So bail hearings tend to last for 30 seconds or a minute. If you're lucky, you maybe get 5 minutes of the judge's time, in which he or she kind of takes a glance at the police report, reads the charges, and depending on the jurisdiction, sets monetary bail or consults with a risk assessment and decides either your bail amount or directly whether you should be detained pretrial or not. The judge is supposed to be taking into consideration your risk of reoffending and your risk of failing to appear in court, and really kind of nothing else. You know, it's risk of crime, risk of non-appearance, and maybe risk of tampering with evidence or interfering with the trial. But what our research suggests is that in fact they're taking in a fair amount of other information in, and instead of kind of weighing these two, the harms of incarceration against the harm of, the potential crime that the person might commit, they seem to be prejudging or evaluating the worth of the arrestee in this calculus. And based on the evidence, they don't value the arrestee very much. They seem to be very much discounting the well-being, the harms that the arrestee will suffer if placed in a jail, exposed to rampant disease, exposed to the violence and sexual violence that's, rampant in our carceral system, exposed to, the myriad of poor conditions ranging from food to, heating failures, overflowing toilets, overcrowding, and so on and so forth.
Can you provide one example in the introduction of your paper that basically says if detaining 10 presumptively innocent people for 3 months is projected to prevent 1 robbery, is it worth it? So I think, go ahead.
Oh, sorry. If I can jump in and add on what Megan, build on what Megan was saying. I came to this topic in large part because I used to be a public defender in New Orleans, Louisiana. And at the start of my time there with other public defenders, I represented people in bail hearings. And it happened routinely that people charged with low-level offenses who were not going to be sentenced to prison. They were not likely even to be sentenced to jail. They were charged with misdemeanors, very, very low-level stuff. Would be there in the bail hearing, and the judge would look at the police report, and the prosecutor would say, Your Honor, he's charged with petty theft. He has 3 prior convictions. He's a threat to public safety. We request bail in the amount of $50,000, some amount the person clearly was not going to be able to make. And the court would say, okay, yes, 3 prior convictions, threat to public safety, bail in the amount of $50,000. And it was mystifying because what was going to happen is this person was going to be stuck in jail, unable to pay the bail, plead guilty at the first opportunity because he would get a sentence of probation and be released. He would plead guilty to go home. And what I could not understand was, why is this person such a threat to public safety that we have to lock him up right now before he's been convicted, but in 2 weeks after he's been convicted and he still has 3 prior convictions, he will be safe enough to release. And so that story is to say that the calculus that judges do at bail hearings is certainly not a rigorous cost benefit analysis. They're not thinking in a clear, rigorous way about whether the benefit of locking someone up actually outweighs the harm that it inflicts.
And it's sort of connecting these 2 points. Something that I'm seeing is that you have someone like the person you were talking about who ends up being incarcerated for 2 weeks with this sort of arbitrary sense of why this person is going to reoffend again. And then in the meantime, facing all of this trauma that pretrial incarceration causes, loss of a job, potential loss of wages if the person has dependents in their home, re-inflicted trauma that could potentially hurt other people who are incarcerated.
Loss of custody. I mean, taking parents away from their kids is one of the worst harms.
Absolutely. And absolutely. And it also serves to think about public safety for who? Because something that I heard you say, Megan, was that it's not considering at all sort of the well-being of the person who is incarcerated. And we know that most of the people who are incarcerated pre-trial are Black and brown. And often it's sort of this re-victimization of a whole segment of the population. So let's talk a little bit more about that. I also want to talk specifically about how in that traditional cost benefit analysis, you have proposed something new. So talk to us a little bit about the current equation that many jurisdictions use and what you would propose instead.
Sandy, do you want to start off by describing the legal framework, what the law says about what is required before someone is detained pretrial?
Sure. So Alana, our paper starts by explaining what you explained at the beginning of this conversation, that the rationale for pretrial detention is not that it is deserved, right? It can't be that because it's pretrial. These are people who are presumed innocent, haven't been convicted. The Constitution prohibits punishment before conviction. The rationale, what the government claims allows it to lock people up, is just as you said, the idea that it's necessary because the benefit in terms of safety outweighs the individual's liberty interest, which sounds like straightforward cost benefit analysis. The benefit outweighs the cost. But as I was just saying, this is not actually a cost benefit analysis that anyone is doing in a very rigorous way. So our paper, we decided to take the apparent cost benefit criteria for detention seriously and ask, when does the benefit of detention outweigh its costs? The next question is, how do you figure that out? There is a traditional cost benefit methodology that I think you were referring to that economists use, and maybe I'll turn it back over to Megan to explain what the traditional methodology would be and why we took a different approach.
Yeah. So traditional cost benefit analyses convert all the myriad of costs, the costs of crime, the cost of incarceration, cost of lost employment, taxpayer costs. They convert them all to dollars, and then you add them all up at the end, the bottom line. So, here's the total cost of a month of pretrial detention. Here's the total benefit of a month of pretrial detention. And the benefit here, at least conceptually, is that you might avert a crime. There is the idea is that somebody's at risk of committing a crime, you might avert a crime. Now, we take a different approach here for a variety of different reasons. We just want to simplify it. We want to simplify it. We want to put at the forefront what we think are the two biggest costs in this equation. There is the cost of incarceration to the person that is placed in that cage, the experience, the harm that person experiences. And then there's on the other hand, the benefit is the averted cost of crime. So the cost of crime for a potential crime victim. So, okay, if we can kind of get at the relative harms of crime and incarceration, we think these are at the heart of the equation. This is the most important thing. So what we do formally is a technique called contingent valuation. This is a very common method in economics to be able to kind of price or value things that aren't bought and sold on markets. This is how all of the estimates of the cost of crime in the literature are generated, or not all, but most of them. We do a modification of that. But I think the easiest way to think about what we do is like that kid's game of would you rather. So what we do is we conduct a survey where we ask a bunch of people questions like, if you had to choose between being the victim of a robbery or spending a month in jail, which would you choose? Almost everybody, by the way, says they would choose the robbery over a month in jail. Almost everybody that we've conducted this on. And we vary that question in different ways. We do shorter lengths of jail time. We do longer lengths of jail time. We do robbery. We do burglary. We do serious assault. And at the end of the day, this is what we learn. We learn that the median respondent says that a single day in jail imposes as harms as grave as burglary. So 3 days in jail impose harms as grave as robbery, and a month in jail impose harms as grave as serious assault. In other words, people are saying jail is horrible. They don't want to be put in jail under any cost. Like, nobody wants to be robbed. Nobody wants their home burglarized. Nobody wants a serious assault. And nobody wants to go to jail even for short periods of time. So go ahead.
It's worth pointing out, I think, at the start that the group of people we surveyed included quite a number of people with personal experience with incarceration on the one hand, and then also with being the victim or someone very close to them being the victim of the crime we were talking about. So for each survey, we did 3 different surveys for robbery, for burglary, and for serious assault. We ran them until we had about 300 responses per survey. And for each survey, there were about 100 people who had personal experience with crime victimization for that crime, and about 100 people who had personal experience with incarceration. And one of the remarkable things about our results that surprised us is that their answers were the same. The median respondent, that's in the middle answer, for people who have personal experience with jail and with crime victimization, was the same as the middle respondent for the whole group. What Megan said: 1 day for burglary, 3 days for robbery, 1 month for serious assault.
That is so interesting to me because, on this show, we often talk about issues having to do with the criminal legal system. And every now and then when I take a look at the comments, I'll often see a lot of folks saying, well, what if it was you who was the victim of this crime? And that's we get that all the time. And so hearing you say that in this survey, people who have been victims of crime, this is their reaction. So talk to us. I'd love for you both to elaborate a little bit more about the survey results and also what you think they reveal about the blind spots of the way we currently evaluate pretrial incarceration. Go ahead.
We both have things to say.
I know, I don't know who to ask, but you go, Sandy, you start.
Okay. I think one of the most interesting thing about this study, the reason we did it this way, is because it requires people to imagine themselves in both situations. And I think what it reveals most centrally is that we usually don't do that. It's really easy for people to think of those who get arrested, those who go to jail, as someone else. It's some group of people, criminals, or just poor people, mostly brown, Black people, some other group of people who we don't have to care about. Whereas when we think about crime victimization, it's much easier for people to imagine themselves being the victim of a crime. And so we prioritize the welfare of that group of people. But that is not the basis on which we should be making cost-benefit calculations. I mean, if the rationale for pretrial detention really is it's supposed to avert more harm than it inflicts, we need to understand the harm that it's inflicting and not discount it because we only imagine it happening to some other group of people.
Yeah. And let me just add on that, like when we're saying we're kind of trying to get in the shoes of the judges that are making these bail decisions, because this is a hugely racialized system. These are primarily white people making decisions about primarily white and upper middle class, that you're earning a judge salary, earning a decent salary, making the decision about poor people and about people of color. And so I think that there is, in our society, there's just a huge capacity of disregarding suffering based on race and class bias. Being able to put yourself to be able to be like, well, what about the crime victim? Well, what about the person who's going to jail based on mere allegations? Like, what about that person, And
And it also seems to ignore the fact that so often people who are victimized are also the same people who end up being charged with crimes and then being re-victimized once they're incarcerated. And that public safety needs to take all of these things into account.
I wanted to highlight that, Alana, because a lot of our respondents, we asked our respondents to explain their answers in a couple of sentences. And a lot of people noted that one of the things they feared in jail was being the victim of an assault in jail, which happens. I mean, the violence is not something that only happens to well-to-do people out in the world. It happens a lot in carceral settings. And if that's what we care about, we should be taking into account when we decide whether it's worthwhile to lock someone up.
Right, public safety for everyone, not just people who aren't behind bars. So in your paper, you also note that your analysis didn't cover every type of crime and that there could be circumstances where pretrial detention is in fact warranted. Can you elaborate a little bit on this? And I'll start with Megan on this one.
Sure. So, we focus on 3 crime types. We look at robbery, burglary, serious assault. There's a few ones that we leave out of our analysis just because we think they're more complicated for a variety of reasons. So there's the risk of very serious tragic crime, murder, rape. And then there's the risk of another type of very serious crime that has domestic assault, which has a kind of ongoing nature. And we acknowledge there might be instances where some sort of containment in order to prevent very serious crime or kind of serial, ongoing, very high certainty type crime is warranted. We don't make a claim either way. We just kind of put those aside. But what we do say is when it comes to kind of the types of crimes we're talking about, which are serious, but not kind of deep tragedy crimes in the same way, or generally not, they're not the level of murder, for instance, virtually nobody should be detained pretrial. And the reason is because we don't have the capacity to predict in advance who's going to be committing these crimes. I mean, our powers of prediction are just not that good. Even with these risk assessment algorithms, which people seem to believe are the best, better than human intuition, incorporate all of the superpower of, computers and big data to predict the future, they're just not that accurate. In one commonly used risk assessment tool, only 2.5% of those in the highest risk category, this is the highest risk group as identified by this algorithm, only 2.5% of them are arrested for a violent crime within a month. Now, at that rate, since a month of incarceration creates harms that are equivalent to a serious assault, only a 2.5% chance of a violent crime. And probably that's a less serious violent crime than serious assault. Most violent crimes are, misdemeanor, simple assault, like a punch gets thrown or something like that. The harm of incarceration simply dwarfs the expected benefits in terms of averted crime. So we think it's the instances in which some sort of containment might be warranted are very limited to very unique situations in which you can demonstrate that somebody poses kind of a specific and kind of identifiable serious threat to safety of another person or persons, and not the kind of garden variety like dangerousness, like, oh, we just think, they're going to commit a crime, like the story that Sandy started off with, that virtually never justifies pretrial detention under the legal standard as it currently exists.
And it kind of creates, and you cite this in your paper, in a footnote, you talk about how it creates this really scary sort of Minority Report world where we're punishing people for things that they have not done. So Sandy, I'll let you jump in here.
Well, I'll just add to make what Megan was saying about the high risk group even more concrete. If we were going to lock up everyone in that ultra high risk group, in the highest risk group, the tool can identify people at high risk for violence, we'd have to detain 200 people for a month to expect to avert 5 assaults, serious assaults. But according to our median survey respondent, we're not justified in depriving more than 5 people of liberty for a month to prevent 5 assaults. Not 200. 200 is a lot more than 5. It's not 3 times more. It's not 4 times more. It's many, many times more. So it's not just that we are detaining some people where it's probably not cost justified at the margin. If our median survey respondent is a good measure of the relative harm of jail and crime victimization, we are detaining people at astronomically higher rates than could be justified on the basis of public safety benefit alone. I think that's important to emphasize. And then on the second, to your question, when is detention justified? We do not in this piece or in our broader research mean to ignore or trivialize the experience of those who suffer crime and assault. Crime victimization is real and important and costly. And as you say, it is most frequent in the same communities from which people are most frequently arrested. I think both Megan and I think that detention sometimes is necessary, and in particular in domestic violence settings where there is specific evidence that a person poses, as Megan said, not just a specific, but an imminent threat to another person. And those situations do arise, but that's not why most of the people sitting in jail pretrial are sitting in jail.
And something I can't stop thinking about, and I was discussing this actually with a colleague before coming on today, is how there is such an overuse on incarceration to prevent these sorts of harms when, why aren't we talking about other types of, so for example, like even for somebody who, let's say we found somebody who we know is going to be super dangerous if they are let out. Aren't there other sorts of things that we can do to prevent that person from being dangerous? Like, why can't we have that person have a life coach move in with them or something to that extent? So I'm interested to hear you both talk about what sort of alternatives we can have instead that aren't, by the way, sort of different ways of restricting somebody's freedom in a way that sort of flies in the face of the presumption of innocence.
Can I say a quick thing, Megan, and then a quick thing about the law? So a quick thing about the law is that in theory, the law generally does require pretrial courts to impose the least restrictive measure that will address a relevant risk. This is certainly true in the federal system. So in theory, this principle, this very important principle that we should only ever resort to detention if there is literally nothing else that could address the threat. In theory, that is codified in many jurisdictions' law. Go ahead, Megan.
So I wanted to say something about a new project that I'm in the midst of working on right now that's relevant to that question, which is I'm gonna like phrase it a little bit different. Like, so we've got this problem of risk in our society, right? Like there's risk, there's crime. The way we have been thinking about risk is that risk is a personal trait. Each defendant has a risk. We can calculate their risk score, and then we decide what to do with the person based on their personal risk. Now, if you decompose the risk score consists both of things that reflect the person's choices and activities. So their criminal record. It's not a perfect measure of those, but it's a proxy for that. And it also includes a whole ton of other things that have nothing to do with your personal choices. It includes, they include your age, gender. It include, a lot of them include socioeconomic factors. Some of them include zip code, the area that you're from. And the bottom line is that the contextual factors are actually better predictors of risk than the personal factors. So with that in mind, like you just think about risk differently. It's like, instead of zooming in on like, what do we do with this person who poses a risk at this particular time? How can we address the contextual factors that create risk into people's lives? And I think that if we think about risk in this other way, it opens up the door to different types of avenues, ameliorating the problems in people's lives that create risk to begin with.
Can I jump in quickly on that? You mentioned ProPublica and algorithms and the disparate racial impact of algorithms earlier. I have a prior article about that topic that's called Bias In, Bias Out. And I could not agree more with Megan. The final argument in this paper, Bias In, Bias Out, is that rather than treat risk with individual restraint, we ought to understand risk as a product of structural forces, which it is. I mean, it mostly is. And just as Megan said, do what we can to address those structural forces. Now, we're going to have to do a lot of that outside the criminal justice system for the reasons that you suggested, Alana. The criminal justice system is not the place to channel all social services to people and address all of the structural inequality and structural problems that give rise to structural risk. But recognizing the structural nature of risk is the essential first step.
And that is a perfect note for us to end on. Let's fix all the structural risks that exist in society and stop producing all of these unfair outcomes in the criminal legal system. Thank you both so much for joining us and for all of the great work that you do.
Thank you.
Thank you so much.
So we've seen today, as is so often in the criminal legal system, that the system of pretrial justice is broken in the United States. And even in places that are moving away from cash bail, we've seen that the ability to be able to gain your freedom before trial depends on so many things that don't actually have to do with safety and are so often skewed against people of color. And as we've just heard, these systems rely on a cost-benefit analysis that's supposed to weigh the potential harms of releasing people versus keeping them in jail. But in practice, these models largely ignore the harm that being incarcerated causes to somebody's life, and not just to their life, but to the lives of other people incarcerated, to the lives of people who are waiting for them on the outside, to the lives of children waiting for them on the outside. And that all too often results in re-traumatization. And our guests created a model that calculated how normal people actually feel about these harms. And people's responses show how completely out of whack our calculations are with these models that weigh the risk of someone committing future crimes against the risk that a person being harmed by being jailed pre-trial will face. And so using a model that more accurately accounts for that harm, both of these offers conclude that virtually no one, apart from some small serious cases, is dangerous enough to warrant pretrial incarceration. And so as the push for pretrial reform continues, policymakers need to confront this reality that jail is a dangerous, harmful place that can do unspeakable harm to people, and that we shouldn't discount that harm and that the harm that people who are incarcerated and their loved ones face. We shouldn't discount that experience when talking about public safety, because the public safety of people who are charged with crimes cannot be divorced from the public safety of society as a whole. And detaining someone awaiting their day in trial is not worth it. So thank you all so much for joining us. This has been The Appeal Live. I'm Alana Sivan. Continue to follow us on Facebook and Twitter for the latest news. We'll see you next time.